Hello everyone, welcome back to the U.S. Immigration News. On his first day back in office and true to his campaign promises, President Donald Trump signed an executive order to end birthright citizenship and issued new rules. So, what does this really mean? Who does it impact, and how? In this video, we're breaking down the details of this executive order, cutting through the legal jargon to uncover the truth behind this controversial move. If you are interested in this topic, please stay tuned until the end of the video. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Let's first briefly understand what birthright citizenship is as per law. In the U.S., the history of birthright citizenship, and periodic challenges to it, has long been tied to the country's fraught relationship with race. The 14th Amendment was a response to the U.S. Supreme Court's Dred Scott decision in 1857 that determined an enslaved or formerly enslaved person was not and could never be a citizen of the United States. Scholars believe the ruling tipped the country closer to civil war, which broke out in 1861, 4 years later. Congress passed the 14th Amendment in 1866, and 3/4 of states ratified it in 1868, in the war's wake. Its first sentence sums up the citizenship right guaranteed at birth: all persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. A court case soon tested whether the amendment also afforded birthright citizenship to children born in the U.S. to immigrant parents. In United States v. Wong Kim Ark, a man born in San Francisco to Chinese parents challenged the government's claim that he wasn't a citizen. Now let's decode Donald Trump's executive order. 1. What does the executive order policy state? The order lays out specific rules that limit who can automatically receive U.S. citizenship at birth, even if they are born on U.S. soil. It introduces two main conditions under which a child born in the U.S. will not qualify for citizenship. Let's look at conditions one by one. Condition 1. The mother is unlawfully present in the U.S. if the mother is in the U.S. without legal authorization, for example, crossing the border without a visa or overstaying a visa, and the child's father is not a U.S. citizen or a lawful permanent resident, the child will not automatically receive U.S. citizenship. For example, a mother enters the U.S. illegally and gives birth to a child. If the father is also not a U.S. citizen or does not hold a green card, the child will not be considered a U.S. citizen at birth. Condition 2. The mother is in the U.S. temporarily, with lawful status. If the mother is in the U.S. legally but on a temporary basis, such as visiting on a tourist visa, studying on an F1 visa, or working temporarily, and the father is not a U.S. citizen or lawful permanent resident, the child will not receive automatic citizenship. For example, if the mother is in the U.S. legally but on a temporary basis, such as visiting on a tourist visa, studying on an F1 visa, or working temporarily, and the father is not a U.S. citizen or lawful permanent resident, the child will not receive automatic citizenship. A mother is studying in the U.S. on a valid student visa and gives birth. If the father does not have U.S. citizenship or permanent residency, the child will not qualify for citizenship at birth. Now let's look at who is still eligible for birthright citizenship. The order ensures that the policy does not affect the citizenship rights of certain groups: children of lawful permanent residents, green card holders. If either parent is a lawful permanent resident, the child remains eligible for U.S. citizenship at birth. Children already entitled to citizenship under current laws, the policy does not retroactively remove citizenship from anyone already recognized as a U.S. citizen. Legal challenges. On Tuesday, a coalition of 18 states sued Trump and federal agencies in U.S. District Court in Massachusetts, claiming the order violates the Constitution. The ACLU filed a separate legal challenge in New Hampshire on behalf of immigrant advocacy organizations on similar grounds. It would, they said, upend a foundational aspect of the United States of America, that anyone born here is from here. The executive order, called Protecting the Value and Meaning of American Citizenship, would prevent federal agencies from issuing Social Security cards, passports, or welfare benefits to U.S.-born children in a sweeping reinterpretation of the 14th Amendment, which guarantees citizenship to anyone born in the United States. The order is scheduled to take effect in mid-February but could be blocked by the courts. With the exception of the children of foreign diplomats, Everyone born in the country is guaranteed U.S. citizenship, also known as birthright citizenship, under the 14th Amendment. Under Trump's order, after February 19, U.S.-born babies must have at least one parent who is a U.S. citizen or lawful permanent resident in order to gain citizenship. The order fulfills a promise made early in Trump's presidential campaign that has for years been a target for far-right organizations wishing to reduce immigration and curb immigrant rights. The right-leaning Center for Immigration Studies estimated in 2018 that roughly 300,000 babies are born annually to mothers in the country unlawfully and argues that children of immigrants create a tax burden. The think tank, which the Southern Poverty Law Center lists as a hate group, has argued for putting the issue in front of the Supreme Court again. The ACLU, American Civil Liberties Union, Tuesday sued on behalf of organizations with members whose babies will be denied citizenship under the order. Denying citizenship to U.S.-born children is not only unconstitutional, it's also a reckless and ruthless repudiation of American values, Anthony Romero, ACLU Executive Director, said in a statement. This order seeks to repeat one of the gravest errors in American history, he said, by creating a permanent subclass of people born in the U.S. who are denied full rights as Americans. Now let's look at, can Trump end birthright citizenship with an executive order? According to legal experts, the short answer is no. President Trump's attempt to end birthright citizenship through an executive order faces insurmountable legal and constitutional barriers. An executive order, which is a directive from the president to federal agencies, lacks the authority to amend or reinterpret the Constitution. Such a fundamental change to citizenship rights would require a constitutional amendment, a process that involves approval from both Congress and a majority of states. Given these factors, while Trump could issue an executive order on birthright citizenship, it would be largely symbolic and would almost certainly be struck down by federal courts as unconstitutional before it could take effect. The order would likely face immediate legal challenges from states, civil rights organizations, and affected individuals, rendering it ineffective in actually changing birthright citizenship policy in the United States. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. Thank you for visiting us today, and we'll see you in the next video. If you haven't subscribed to our channel, please subscribe to the channel for more U.S. immigration update videos.